これよりパネルディスカッションを開始いたします。テーマは、知的財産紛争解決の国際比較です。それでは、パネリストの皆様をご紹介いたします。知的財産高等裁判所、本田智成所長。知的財産高等裁判所、天野健二裁判官。大江橋法律事務所、重富孝光弁護士。大韓民国特許法院、イ・ヘジン裁判官。キム&チャン法律事務所、ハン・サンウク弁護士。キム&チャン法律事務所、イ・シオル弁護士。デリー高等裁判所、ジャシャワント・バルマ裁判官。アダルシュ・ラマヌジャン法律事務所、アダルシュ・ラマヌジャン弁護士。サイクリシュナ&アソシエイツ、サイクリシュナ・ラジャゴパール弁護士でございます。モデレーターは、知的財産高等裁判所、勝俣久美子裁判官。安倍育保片山法律事務所、黒田薫弁護士。以上の皆様でパネルディスカッションを行います。それではここからの進行をモデレーターのお二方にお願いしたいと存じます。勝俣裁判官、黒田弁護士、お願いいたします。
はい、ご紹介ありがとうございます。最初にご案内をいたしますが、今日、各国、日本、韓国、インドの、模擬裁判行われましたが、その判決については今、JCIP のウェブサイトにアップロードされています。参考で日本語訳もつけていますので、ダウンロードできる方はご参照いただきながらパネルディスカッションを見ていただければと思います。それから今表示しているスライドについても、同じく、JCIP のウェブサイトにアップロードしていますので、ご参照いただければと思います。So now let's start the panel discussion. The theme of the panel discussion is IP dispute resolution at various jurisdictions. In the first half of the panel discussion, the speakers from Japan, Korea, and India will give us the presentation about the process of IP infringement cases and the digitalization of the code. And in the second half of the panel discussion, we will discuss about the mock trial and the doctrine of exhaustion, which are the main issue of the mock case. So the first topic is the process of IP infringement cases. The first topic is, in this part, I would like to start with the presentation on the process of IP infringement cases and also the digitalization of the code. The presentation will be given in the order listed here. First, Chief Judge Honda from Japan, and then High Court Judge Lee and Mr. Han from Korea, and then Justice Verma from India. So the first presenter is Chief Judge Honda Tomonari from the Intellectual Property High Court of Japan. The title of his presentation is The Process of IP Infringement Cases in Japan. He is going to give the presentation in Japanese, so please use the receiver to listen to the simultaneous translation. Is it okay? では本田所長お願いします。
ではよろしくお願いいたします。私からは、日本における知財侵害訴訟の手続きについて簡潔にご説明申し上げます。知的財産権侵害訴訟とは、特許権、商標権、著作権、不正競争による営業上の利益等の侵害を理由として、損害賠償や侵害行為の差し止めを請求する事件であります。知的財産権侵害訴訟についての我が国の裁判の管轄についてご説明いたします。知的財産権侵害訴訟のうち、特許権等の技術系の事件につきましては、知的財産権関係民事事件を取り扱う専門部を有する東京地方裁判所、または大阪地方裁判所の専属管轄とされています。また、その控訴事件は、知的財産高等裁判所がすべて取り扱うこととなっております。他方、意匠権、著作権等の非技術系の事件につきましては、土地管轄に応じて全国50カ所にある地方裁判所が管轄を有するとともに、東京地裁、または大阪地裁にも選択的に管轄権があります。その控訴事件は、第一審を取り扱った地方裁判所に対応して、全国8カ所にあります高等裁判所が管轄を有します。そのうち、東京高等裁判所の管轄に属する事件を、知的財産高等裁判所が取り扱っております。これが管轄を、図で示した、ものとなります。次に、知財高裁の裁判官についてご説明いたします。知財高裁の裁判官は、法律職の資格を有する者によって構成されておりまして、知的財産権に関する専門裁判所に所属する裁判官として、多くの知的財産権事件を担当して経験を積むとともに、研究会に参加するなどして研鑽に努めているところでございます。知財事件のうち、特に技術系の事件につきましては、裁判官が具体的な事件を審理判断するにあたって、関係する専門的知見を得ることが大変重要でございます。そこで、知財高裁、東京地裁及び大阪地裁には、専門的知見を得るために、裁判所調査官が配属されています。裁判所調査官は、裁判所に所属する常勤の職員でありまして、専門的知識及び特許法等に関する知識を有する特許庁の審判官等の経験者や弁理士、出身者から構成されております。裁判所調査官は、裁判所の命を受け、特許等の技術型の知的財産権関係訴訟に関与し、当該事件の審理、裁判に関して必要な技術的事項を、調査しております。加えて、専門的知見を得るための方策としまして、専門委員制度が活用されています。専門委員は、最高裁判所が任命する非常勤の国家公務員であり、多岐にわたる各専門分野において最先端の科学技術に従事している大学教授、公的機関の研究者をはじめとする全国の各専門分野の第一人者により構成されています。専門委員は訴訟関係を明瞭にし、または訴訟手続きの円滑な進行を図る必要があるなどの理由により、裁判所の決定により指定を受けた事件について関与し、その専門的な知見に基づき、公平・中立的な立場から争点となる高度な専門的・技術的事項について説明等を行います。次いで、技術説明会についてもご説明いたします。当事者から技術的事項について口頭で説明を受けるため、期日において、 技術説明会が実施されることがございます。先ほどの模擬裁判で、日本の模擬裁判で、実施したものでございます。技術説明会の期日には、裁判官、その事件を担当する裁判所調査官及び裁判所書記官と当該分野の専門家から選ばれた専門委員が立ち会います。スライドの11ページを11枚に、技術説明会では当事者から発明の内容や先行技術、出願当時の技術常識といった技術的事項を中心としてプレゼンテーションソフトを用いて要点を捉えた視覚的、効果的な説明がされます。すみません。プレゼンテーションの後、当事者相互官や専門委員、裁判官、裁判所調査官から当事者に対して、当該プレゼンテーションの内容や従前の主張、立証で不明確な点等についての質問がされたりして、自由な雰囲気で議論が行われています。すみませんでした。で、次に行きましょうか。次いで、知的財産権訴訟における審理方式についてご説明いたします。我が国の知財権侵害訴訟では、2段階審理方式によって審理を行っています。第1段階において、特許権の侵害の有無、これは無効論を含むものですが、これを審理し、侵害の申しを得た場合、第2段階として損害論の審理を行っています。最後でございますが、我が国における裁判手続きのデジタル化についてもご説明いたします。我が国の裁判所では、裁判手続きにおいてデジタル技術の活用を図っているところでございます。知財高裁では、現在、ウェブ会議等の IT ツールを利用した争点整理が行われており、その実施割合は対象事件のうちの多数を占めるようになっています。また、技術説明会は一方の当事者または専門委員がウェブ会議で出頭して開催する方式で行われることもございます。これが、弁論準備手続きや書面による準備手続きの、実施の模擬事例でございます。知財高裁では2022年6月から準備書面や書証の写し等を電子的方法により提出するための民事裁判書類電子提出システム、通称ミンツと呼ばせていただいておりますが、の運用を開始しておりまして、対象事件の多くで利用されているところでございます。これがミンツの、ホーム画面、それから書面のアップロード画面の例でございます。また、2022年5月に成立した民事訴訟法等の一部を改正する法律において、訴えの提起から判決までの手続きをオンライン化するための規定、すなわち訴状等のオンライン提出、それからウェブ会議による口頭弁論期日等の実施、訴訟記録の電子化等の規定が設けられました。この改正法は2026年までに施行されることとなっておりますので、同法施行後は知的財産権の関係訴訟手続きのデジタル化がより一層進展する予定でございます。以上でございます。ありがとうございました。
Thank you, Chief Judge Honda. Next presentation will be given by Mr. Han Sang-wook from Kim Chan, and followed by the presentation by High Court Judge Lee Hae-jin from the Intellectual Property High Court of Korea. So please start the presentation. Do you have a clicker?
Thank you. I will give you the brief presentation for the IP infringement lawsuit in Korea in general. IP jurisdiction at a glance. At the top of the judicial system, we have the Supreme Court. The basic system is quite similar to the one explained by the Judge Honda just before. So we do have the IP High Court, and below that, IP TAP. This is the organization which review the validity issue exclusively, and then the infringement issue will be heard by the district court. And then IP TAP and district court, the appellate level, the review was handled by the IP High Court. This is basically the patent and utility model, and then trademark and design, and then the patent, the plant variety, but the other copyright and unfair competition was discretionary review by the root, but the general civil court also can have the jurisdiction over this copyright issue. So concentrated jurisdiction before and after. Before the Korean the IP High Court only reviewed the appeal of the invalidation action. However, since the effective from the January 1st of 2016, the civil procedure law and the court organization law was amended to provide the exclusive IP jurisdiction for the focused and in-depth review of the certain IP matter in the first and second instance. So what happened was, the first instance case, there are 6 the district court: Seoul, Suwon, Daejeon, Daegu, Busan, and Gwangju. There are 6 the court enjoy the exclusive jurisdiction on the patent and other listed right, while with the selective jurisdiction to the Seoul District Court, Central District Court, which means that if you have any patent infringement issue, and then if you would like to file the litigation in Korea, Seoul Central District Court will always has the jurisdiction. And in addition to that, you can choose other 5 the district court, depends upon the situation. And then appeal will be exclusively heard by the IP High Court, as I just explained. So like in Japan, the Korea has the bifurcated jurisdiction, the infringement case and validity case. And then what happened when the infringement court will have some doubt on the validity issue, we do have the Supreme Court decision, which is quite similar to the Japanese the Supreme Court decision, meaning that even before the infringement court, if the infringement court judge will have the serious doubt on the validity of the patent, they may reject the plaintiff the petition based on the abuse of the right. So I will explain the efforts for the in-depth review. We do have the technical examiner and judicial technical researchers. So before the IP High Court, we are having more than 20 the technical examiner and judicial technical researchers. But in addition to that, I'd like to put the emphasis on the recent the development that the young judges, IP judges, who has the technical background, has been increased. So therefore, in addition to that, the IP judges who has the technical background, and then technical examiners and the technical researchers are making the great contribution to the in-depth review of the technical issue. And in addition to that, we do have the technical advisors in each field, about more than 100. So issue by issue examination in the infringement, the lawsuit, the technical, the presentation, and then as you can see in our mock trial, we do have from time to time the expert testimony. I understand that Japan has rarely has the expert testimony for the IP case. But in Korea, I think generally has more the witness testimony in the IP case than in Japan. Last one, the international division. Somebody may heard of that, or somebody didn't. But we do have something special for the foreign companies. We do have the international division system, and then IP High Court and Seoul Central District Court established the international division, where the foreign language can be the language before the court. So in order to establish this international division, the Korea has revised the law which is related to the organization of the court. Previously, the law on the organization of the court has the provision that only the Korean language should be used before the court. But now, we may use the English before the Korean court if this international division will be decided by the court. However, the consent of the other party, consent of the plaintiff and defendant should be required. And then court also may refuse to proceed as an international the case if significant delay is expected. However, I think that this is very good the opportunity for the foreign companies to have more speedy and fair trial before the Korean court. The law says that the foreign language is okay, not limiting English, but the rule before the law has the provision that for the time being, English is the only languages. Therefore, Japanese language is not yet allowed under the rule, but if your interest will be increased, I think the change of the rule is not as difficult as the change of the law, as you know, because the Supreme Court may, if necessary, may revise the rule. Okay, so that ends my presentation, and then after that, Judge Lee will continue to the presentation.
I'll start. Good afternoon, everyone. My name is Hasan Lee, and I am High Court Judge of Korea who specializes in IP law. And I'm here today to highlight Korea's video trial and electoral litigation system. First, let me explain Korea's video trial system. Video trials were adopted in Korea around December 1995, about 30 years ago, for residents in remote mountainous regions with poor transportation access. Around March 2016, the video trial system was enhanced to allow witnesses to testify via video trial. In June 2020, the system was improved to conduct pre-trial hearing for those who cannot attend court in person due to COVID-19. In November 2021, as the social distancing policy continued, the system was enhanced to oral arguments. Currently, video trials are used for oral arguments, pre-trial hearing, examination, mediation, witness examination, and so on. Since COVID-19, video trials have become increasingly popular. From November 2021 to April 2023, over 10,000 cases were conducted via video trial. The Judiciary of Korea has obtained a license for Video Connect program from Video Incorporated. The program is installed on the court's intranet server. As a result, The system offers 4 major benefits: robust security, convenience, satisfying speed, and good quality. This picture was taken from a pre-trial hearing conducted via video conference. For mock trial, this is what our electronic courtroom looks like. This ensures a technical explanatory session in the presence of both party and technical advisor and judges. The parties may use presentation material with photos and videos and explain technical matters. The scene shows the process of witness examination. As you see, attorneys, both plaintiff and defendants can argue in video trial by displaying documents and evidence on the screen, just as they would in the electronic courtroom. Now I want to explain the current electronic litigation system developing in Korea, called the Electronic Case Filing System, or ECFS. The ECFS was first adopted in the IP High Court of Korea in April 2010. Currently, except for criminal cases, the ECFS is used in nearly all cases in Korea. Using this system, litigants can file complaints and exhibit from their homes and office via the ECFS, and they can receive their opponent's submissions through email and text messages. Judges and court clerks can manage the case procedure, review filings, and approve requests through the automated system. Notably, since 2020, as much as 90% of patent cases or more have been processed electronically. You may be interested in the next generation electronic litigation system in Korea. In December 2019, the Task Force for Next Generation Electronic Litigation was established to build the system in earnest. Due to time constraints, I will explain only 2 essential features of the system. First, the system will feature an AI chatbot guide system. This AI chatbot uses big judicial data to answer questions on court proceedings. Second, the system will feature intelligent case search. When judges or law clerks input case numbers, the system will use big data and AI to search for cases with the most similar issues. I believe it is possible to introduce a metaverse code in the future. I want to conclude my presentation by highlighting the impact this technology could have on our international judicial community. IP litigation cases in the world are found to be very similar in terms of disputes, handling procedures, and court precedents. AI and big data apply to all technological fields, and disputes occur globally, not just within countries. Advances in technology are accelerating integration and globalization. Our IP court and offices need to keep up with this trend. It is also clear that the constraints of physical distance are no longer an issue with the adoption of these technologies. As you know, the European Unified Patent Code has been established. So why not an Asian Unified IP Community, or AU-IPC? In the Bible, King David said, "How good and pleasant it is when brothers live together in unity." This symposium is the unity King David spoke of, where Asia come together to share legal system for IP disputes, understand each other, and discuss solutions. Now is the right time for us to start discussion on establishing an AU-IPC. Thank you for your attention.
Thank you, Judge Lee and Mr. Han. So next, Justice Vashrant Verma from the High Court of India will give a presentation on the state of the digitalization of the court in India. Please give us a presentation.
So, while e-filing of matters across high courts is prevalent in India, for the sake of brevity, I'll refer only to the system which has been adopted by the Delhi High Court. So Delhi High Court follows a very simple, easy to use format for e-filing. It commences with you having to first register on the system. And while we had initially started with e-filing in 3 limited jurisdictions, right now it is available across all jurisdictions, including IP matters. So, like I said, you have to essentially first register on the portal to be enabled to make an e-filing. It generates a user registration number, which is unique to the particular advocate. It is confirmed through email as well as through an SMS which is sent. And once you finish the logging, you can now start filing across any kind of matters across jurisdictions. The first screen where you will arrive once you're registered is the one that you see before you. So, and the system, what it does is it essentially captures most of the data required with respect to whether it is a main case, application, documents in a pending case. And with the aim essentially being of capturing all required data which can help us in classifying matters, in identifying matters, or using different parameters for the purposes of search. So for instance, where you will add plaintiff or the respondent, all the relevant details will get captured at this stage itself. You also have the ability of specifying the case type, depending on what jurisdiction it relates to, the number and year. And once this is filed, it'll also show up if there are any defects which have been pointed out. If so, you'll be able to see the scrutiny reports and attend to them. And once that is through, the file will get electronically transferred to the appropriate court. Well, so far as court proceedings through video conferencing is concerned, while Delhi did have the system in place from before COVID-19, it actually took off more post that. And once the country went into complete lockdown. Till about 31 of July, the High Court itself heard over 0.318 million cases via video conferencing. Your district courts, which are the trial courts, have heard almost 4.77 million cases since then. This would be a normal setup in any court, with the first photograph on your left showing how the advocate would be seeing or viewing the judges. The second on the top right shows the view from the judge's chair. On my visit to the IP High Court, I had also seen the display boards that are placed out there. The ones that we use are slightly different in the sense that they tell you not just the status of the case ongoing at that time in that particular court, but also of all other item numbers or case numbers which are being simultaneously heard in other courts. So this is a closer look from the judges' side. So if you have two judges presiding over a bench, so you have the system over there. Delhi High Court is totally paperless. We don't use paper at all. We are trying to convince the lawyers to follow suit. Hopefully they'll also learn. And this is another side from where Mr. Rajgopal or would see how the bench is placed. That's another look of the display boards which we use so that anybody who's joining on video conferencing can see all parties. So they'll be able to see the judges, they'll be able to see the other attending parties all on one panel. That's a closer look of our display board, which is not just there in all courts, but in all corners of the court hall. This is the kind of window which would pop up on one of our screens while we're hearing an e-file matter. So you have the list on the left which shows you what are the matters posted on the day. You have a notebook next to you, and then once you open, you have all files on a PDF format which can be edited, written upon. You can make notes simultaneously. All this was part of a e-courts project which was launched by the Government of India in 2007. We've gone through almost 3 phases of it. So we've already set up the e-court national portal or the National Judicial Data Grid, which will tell you and provide you all details, not just of all or any case pending in any trial court of the country, including the high courts as well as the Supreme Court now. So it is a great analytical database for people to exercise and find out new ways of speeding up matters, speeding up disposal. It throws up amazing statistics. It captures the data of almost 70 million pending and disposed of cases, all on one portal. Digitization was an issue which was faced by courts in India also with respect to legacy data. And you had buildings full of papers. So Delhi High Court commenced its digitization process in 2006. Presently, and up till now, we've digitized 210.65 million pages of judicial records. And we've completely done away with all old data which was stored in physical form. All current filing in the Delhi High Court is on e-filing basis. So we accept no paper now. And the entire records have now been digitized. So just to give you a broad overview of how we do the digitization process is to accept the filing, and on the right-hand side you would see all the voluminous data in paper form which used to exist, all of which has now been completely digitized, and we got rid of all this paper and freed up lots of space, and of course made a permanent record for ourselves. We also have an e-inspection system where all court records, they are in the public domain, can be downloaded by the advocates on record who are the representing parties. So the entire e-file of any case record maintained in the Delhi High Court can now be accessed on the click of a button. We also upload all our orders, documents, judgments on our servers. You can download it by just accessing the website. In fact, even certified copies are now being issued on the basis of these digitized record. Apart from those, we also enable parties to take digitized records on CD, DVD, or now other formats that are available. So some of the benefits that we've kind of gathered from this are also shown in the course of the implementation of the e-courts project. And I'm sure, hopefully by phase 3, we shall be able to take it even further. Thank you.
Thank you very much, Justice Barma. So I'm really impressed that the digitalization of the court well realized in Korea and also Delhi High Court. And the situation of both countries encourage our progress towards further digitalization of the court in Japan. So now I'd like to ask some questions about the to the speakers. So my first question is to Mr. Han. According to your presentation, since 2016, the IP High Court of Korea has exclusive jurisdiction over civil appeals regarding IP cases as well. So the jurisdiction of the IP High Court of Korea is really similar to Japanese IP High Court of Japan. So, and my question is, how do practitioners like you in Korea feel about the change in jurisdiction? And also, if you have any comments on the future plan of the IP High Court of Korea, please share with us.
Thank you. Actually, as an attorney and practitioner, I personally very welcome the change of the jurisdiction, because the change of jurisdiction, the direction of the change of jurisdiction is to more strengthen the expertise by the court. So it was in parallel with the increase of the technical advisor and technical examiner. Therefore, I think that as a practitioner, this is the right direction we should go. And then secondly, the future plan of the IP High Court, I can say two things. First, hopefully the international division case may be the increased and expanded to cover the most of the international IP dispute in the world. And then secondly, as Judge Lee pointed out in the last page of her presentation, actually, we are talking about the existence, the theory in Japan, Korea, and India today. But not surprisingly, basic the factors to be considered by the court in each country is very similar, as you can notice, which means that the IP issue will become more common in nature. So the same issue can be handled by the court in various countries at the same time. Therefore, I totally agree with the direction suggested by the Judge Lee. Like in European country, the UPC has been launched, but even among the Japan and Korea and India, we can start to discuss how we can unify the IP system. This is a very good start.
Thank you very much, Mr. Han. It's a very suggestive request or suggestion, but thank you very much. So I have, so next. Maybe I'd like to ask Justice Barma about the procedure of interlocutory injunction. Okay. I understand that the mock trial of India was performed the preliminary injunction. My question is it usual to have an oral argument before the court if in the process of preliminary injunction or not?
So, since we follow an adversarial system of litigation, hearing on the interim injunction would be as a matter of rule rather than an exception. So every application for injunction that may be made would have to be placed before court. The applicant would have an opportunity to address submissions. It would, of course, be open for the court to consider granting it ex parte or awaiting the defendant to be placed on notice to appear and then to and then to consider the grant of an injunction.
Thank you. And I have one more question about preliminary injunction. The party can insist the defense of validity before issuing the court issuing the interim order.
So the power to issue an interim injunction essentially flows from Order 39 of our principal code that we follow. It's called the Civil Procedure Code. It was framed way back in 1908, but holds the field. And in terms of that, we are empowered as courts, all courts, to grant an injunction, temporary or permanent. Temporary can be either without notice to the defendant or after notice. It operates during the pendency of the suit. We follow three basic principles, which is a prima facie case being established, balance of convenience, and irreparable loss. So although in patent litigation, everything could possibly be ascribed a money value, and one could always argue that no need for the grant of an injunction. It can always be compensated in terms of money, but we don't follow that. So if it's a prima facie case of infringement is made out, an injunction is bound to follow.
Okay, thank you very much. Now I'd like to move on the next topic. So mock trial. First of all, I'd like to express my sincere appreciation to all the speakers from Korea, India, and Japan who have conducted wonderful mock trials. I was so impressed. So in the second half of the panel discussion, we would like to all panelists to talk about the mock trial and related legal issues. So quick look at the mock case. In this case, the Cori, a subsidiary company of the plaintiff, sells the plaintiff's products. Plaintiff's roll paper in country B, and Tato, the subsidiary company of the defendant, collects the part of the plaintiff's product, the court tubes from users, and manufactures the defendant products using or modifying the collected court tubes in country B. The defendant imports the defendant products into country A and sells them to users. So therefore, the plaintiff files a patent infringement lawsuit against the defendant, seeking an injunction. So the decision of the court in each jurisdictions are shown in this table. The Court of Japan and Korea upheld the plaintiff's claim. On the other hand, the Court of India dismissed. So in terms of reasoning, all jurisdictions concluded that international exhaustion was at least virtually recognized in this case. But there was a difference in the decision as to whether the defendant product was considered to be a new product. In the mock case, there are two main issues. The first, international exhaustion, and second, the repair and produce problem. in order to facilitate the mutual understandings of the difference between three jurisdictions on this issue, I'd like to start the discussion with the judges. On the issue of international exhaustion, all jurisdictions virtually adopt the doctrine of exhaustion in this case. I mean, in all three jurisdictions, if the defendant has bought the plaintiff's product in the market and imported them and sold them as they are, the plaintiff cannot claim infringement. So I'd like to look at the legal framework of each jurisdiction. So first, Judge Amano, could you explain basic idea of international exhaustion in Japan?
Okay, I'm gonna speak about Japanese law briefly. Regarding the issue of exhaustion of the patent right, Japan has no statutory provisions. It means that there is no written text in the patent law in Japan. Instead, we have a Supreme Court case in 1997 called BBS, which shows that the positive view of the doctrine of national exhaustion. But about international exhaustion, however, the Supreme Court says that it's a little different because the patent right in Japan is not identical to its corresponding right in another country. So the court does not use the term exhaustion in the context of international exhaustion. Go on to the next slide, please. But the court also held that in conclusion, once the patentee put the patent product on the market legitimately in another country, they may not exercise the patent right in Japan unless two conditions are both met. Condition number one, the agreement between patentee and assignee to limit the region of the sales and exclude Japan from it. And the condition number two is explicitly indicate that agreement on the product itself. So I can summarize that Japanese law does not explicitly and unconditionally admit international exhaustion itself. But by using a kind of implied license doctrine that was very powerful 25 years ago, it virtually limits the exercise of patent rights in these international market transactions. So, but there was a U.S. Supreme Court case called Lexmark case. So, implied license doctrine it has rules. I think implied license doctrine has lose its power a little bit. So maybe it could be different from that time. That's it.
Thank you, Judge Amano. Next, I'd like Judge Lee to explain how to think about international exhaustion in Korea. Do you have any legal provisions and any precedents in Korea?
No provision in Korea Patent Act expressly recognized the exhaustion doctrine. The only court precedent on the issue is the lower court decision of Seoul District Court Eastern Branch 81 Kahab 466 in 1981. The plaintiff manufactured a drug in Italy and exported it to a Swiss company. The defendant imported it from Switzerland and sold it in Korea. The lower court has taken a position based on the international exhaustion theory. The court ruled in this case as followed. Although patent rights in each country are independent and individual acts of working a patent are also separate, the patent rights were already exhausted when the patentee manufactured the product on his or her own and lawfully exported it overseas. In sum, the court ruled that the plaintiff patent rights had already been exercised and exhausted when the plaintiff exclusively manufactured the above drug and lawfully exported it to Switzerland. Therefore, the patent rights are not infringed, even if the patented product was imported from a third country without the patentee's permission. That's all.
Thank you, Judge Lee. And next, I'd like to ask Justice Verma. I understand that in the mock trial of India, the parties have argued whether the Section 107AB of the Patent Act stipulates the doctrine of international exhaustion or not. Is that right? And could you explain about the provision?
So fortunately, we, unlike Japan and Korea, were not sailing in uncharted waters. So we had a statutory provision. The only issue was whether we could say that it is an embodiment of the international exhaustion doctrine. And not just from the contemporaneous material which Mr. Rajagopal referred to, alluded to, and which preceded the introduction of 107A, but the provision itself spoke of importation and by a person who has been duly authorized under the law. And again, we found that in 2005, India did away with the concept of an express authorization from the patentee. And that's also something which helped us in guiding in guiding us to answer the scope of 107AB.
Thank you, Judge Parma. And here I'd like to ask a fundamental question about the common law system. Because we Japanese people are not familiar with the common law system. So, I'm impressed that you have taken into account a lot of case law. For example, in this shown in this slide, you have referred to the U.S. case and also the Australian case in order to explain the grant of the patent exhaustion. So my question is there any rule when you refer to case law, such as any particular country's case law is more important than others? And when you examine the case, which do you look at first, the case law or statutes?
Well, answering the last one first, case law over statute, no, it has to firstly be the statute. And if there be ambiguity, then of course you will go looking for a precedent which may shed light. So, to your first part of the question, so India also came to adopt the common law. It inherited the common law when the British exited. So any judgment which has been rendered by a common law country, like say the UK, the US on some subjects, those would all be precedents which we may legitimately take into consideration. But when it comes to emerging fields and questions like patents, depending on a review of the competing statutes, the complementing statutes in the two countries, we would be open to consider decisions of all expert bodies, and whichever may help us see the light. So we could go to the BDH from Germany or to the EPU. So we keep looking at all kinds of material to see which would help us find the correct answer and show us the way.
Thank you very much. It's very interesting. So I'd like to move on to the next topic. So we will look at repair and produce problem. The conclusion of the mock trial varies depending on the decision on whether the defendant's act constituted impermissible production or permissible repair. In other words, whether the defendant product was considered to be a new product. Japan and Korea concluded that the defendant's product was a new product, but India concluded that it was a repair or refurbishment. So I'd like to ask three judges again what the legal framework is in each jurisdiction for examining the defendant's product on this issue. So at first, again, Judge Amano, could you explain the situation in Japan?
All right. Okay, I'm going to speak what happens in Japan when the legitimately sold products have been modified or repaired. We also have a Sprint case here in 2007 called in cartridge case. It's a little complicated, but in a nutshell, the court says if something has done to the product to the extent that it is deemed as a new production of the patented product or lost identity of it, the patentee may exercise the right to that new product. Next slide, please. Quite simple. But how do we determine whether there is a new production or loose identity of the product, which was infringement, or just fixing the product, which is the holder's legitimate right on the goods? And the Supreme Court says that we should consider many factors, which is on the slide here. So the factors are how the product's like, how the patented invention like, how the modification like, and how the market's like. Next slide, please. In the mock trial today, court firstly pointed out that the plaintiff's roll paper does not expect or it's not designed to end users to remove the core tube and buy a new paper and wind it by themselves. Next, court pointed out that the market value of seed itself, and it is on the slide. Maybe not on the slide here. The court mentioned that the effect of the patented invention, which are detecting an angle and adjusting the braking force, are restored by winding the paper to the tube correctly. So I can say that it seems that the court took those points into consideration and found that the defendant product is newly produced patented product. That's it.
Thank you, Judge Yamano. So, next, Judge Lee. I feel that you examined the mock case with a similar consideration to the Supreme Court decision in the trademark case called Fujifilm single-use camera case. Could you briefly introduce the Fujifilm case and also please give your opinion on whether the theory of the Supreme Court case on Fujifilm is applicable to any kind of IP cases, including patent case?
Okay. The mock trial judgment seems to be based on a similar theory of the Supreme Court decision, 2002-3445 rendered in 2003, relating to the Fujifilm single-use camera case. The defendant was charged with trademark infringement for selling a used Fujifilm single-use camera body with a new film, another company's film, not Fujifilm's. The Supreme Court ruled in this case as follows. Unless there are exceptional circumstances, when a trademark owner, etc., transport a product bearing a registered trademark in Korea, the trademark rights to the product shall be exhausted as having achieved its purpose and do not affect the product use, transfer, and lease. However, if the product has been processed or modified to the extent that the identity of the original product is lost, it can be evaluated that the trademark owner's right shall be considered infringed. It shall be decided whether the product has been processed or modified to the extent that the identity of the original product is lost, and therefore the act of producing has taken place based on comprehensive assessment of the objective nature of product, the use form, and the legislative purpose of Trademark Act. We looked at the summary of the Supreme Court decision relating to the first film single-use camera case. You think that it's very similar with the mock trial decision, is it right? While the Supreme Court case above is about trademark exhaustion, I personally think the reasoning is applicable to the other IP cases as well. The mock trial judgment was rendered based on comprehensive assessment of the description of the patented invention, the objective nature of the product, the use form, the legislative purpose of the Patent Act, etc., to determine whether the defendant's conduct constitutes an act of production that harms the identity of the patented product, and thus constitutes patent infringement. It is not appropriate to dichotomize the issue of whether the international exhaustion principle applies to single-use patented products. In my opinion, the comprehensive assessment of the above factors can lead a reasonable and specific conclusion. That's all.
Thank you very much, Judge Lee. And I'll skip this slide. And the next, Justice Verma from India. In your decision on the mock case, you mentioned that there are two exceptions of the exhaustion doctrine. The first exception is the purchaser makes the patented product or replicated the invention. And second, when the patentee expressly limited the right of purchaser. In the mock case, the first limitation was important. So could you make a supplementary explanation on the principle of permissible repair and impermissible reconstruction?
So, starting from first principles, of course, the right of the patentee has to be protected. And that's the promise that we made and forms the bedrock of the patent bargain, so to speak. But at the same time, we feel that there should not be an unjustified extension of the monopoly right. And if we are accepting parallel imports as an accepted policy itself, then we would have to necessarily find the distinction in each case between a make and a repair. And that's why we feel that this principle of permissible repair and impermissible reconstruction gives us a safe and surer way of going forward than getting lost forever in the complexities attached to the word making. And even the House of Lords speaks of it as of one of fact and degree. So when you keep those factors in mind, perhaps that's where we came to the conclusion that we did. But of course, the minority should speak the least.
Thank you very much. I'm really interested that the India, the right of personal property is very important. So than I thought usually. So maybe it's a kind of a reason of the difference of the conclusion. So, Do you have any comment on that?
Not really. So, personal property is one part of it. And of course, it does bear an important, it's an important factor. But if you'd also recollect that we noticed two observations in United Wire for one, which said that even if you acquire it as an article and you have personal property rights, you can't replicate it. You can't reconstruct it. You can't copy a product and say that the doctrine of exhaustion does not apply because I bought it. So that's the balance that we'll have to bear in mind.
Thank you very much, Justice Verma. So, I would like to a small wrap up about the discussion between judges. Through the explanations given by judges, I think we can understand the legal framework in this issue a little in three jurisdictions. This table shows the conditions each court considered in order to determine if the defendant's product is a new product in the mock trial. So, and the nature of the invention and the characteristics of the defendant's product are considered in all jurisdictions. But it is very interesting that the conclusion was different. Yes, it seems to me that Japan and Korea put importance on the function of the whole patented product. On the other hand, India considers whether the packaging sheet, which is replaced by the defendant, embodies the inventive element of the set patent. So in addition, as I said before, I understand that the right of personal property is much more important in India than I thought. So in my opinion, it could be the constitute part of reason for the difference in the conclusion. So now we just should hear the opinion of attorneys. So I will hand the role of moderator to Attorney Kuroda. Please start the discussion.
Okay. Can you hear me? Let's start the discussion between attorneys. In this session, I'd like to hear the comments from the attorneys on the differences between three jurisdictions on the issue of exhaustion. First, Shigetomi-san, could you please let us know your thoughts on the differences from Japanese attorneys' perspectives?
Okay. Yeah. Thank you for the question. First of all, to me, it was very interesting to know the difference of the reasoning and the factors to be considered in the court decisions with regard to the issue of repair and the reproduction issues in Korea, India, and Japan. And so as I saw the slide number 24, I found that the Korean courts tends to relatively consider the objective nature and the use form of the product. Okay, and on the other hand, the Indian court tends to relatively consider the nature of feature of the patent or invention. In contrast, to me, in Japan, I recognize that the court tends to make a comprehensive assessment of various factors in comparison with Korea and India.
Thank you for your comment. Do you have any particular question or comment to any of the attorneys from Korea or India?
So I have a question to Korea first with regard to the repair and the reproduction theory. As to the issue of such issue, the Korean courts will consider the objective nature and the use form of the product. Such consideration may affect the parties' patent practical strategy, how to deal with the repair and reconstruction issues. In this regard, here in this mock trial case, if in the case that the defendant successfully proves that the following two factors, do Korean attorneys think that the defendant will obtain the non-infringement or favorable decision? Here is the two factors. Factor number one is the rotation angle of the defendant roll paper is precisely measured, and the braking force is also properly adjusted according to the external diameter of the roll paper. And the second factor is that in trade practice, the many users of the roll paper use the quad tube more than one time. That is my question.
Thank you for your questions. The short answer to your question is yes. The court will likely find that the patent is exhausted. So if the factor numbers 1 and 2 are proved, then the court will likely found that the replacing of the packaging sheet is not corresponding to the replacing of the essential parts of the patented products, so that the patentee claims could be dismissed. Thank you.
Thank you. How about any question to the Indian attorney?
Okay, thank you. Yes. So today's panel discussion slide, slide number 20, I saw that there is a limitation of the doctrine of exhaustion. Number 2, express negative covenant or stipulation. Okay, so I have one question with regard to this topic. And in India, so I think I recognize that the patentee can prevent the doctrine of exhaustion in case that the patentee imposes express negative covenant or stipulation with respect to the product. So in this mock trial case, if the patentee imposes the express prohibition of reuse of the quad tube, can patentee prevent the direct purchaser of the roll of paper from refurbishment or replacement? That is my number one question. And also, the second question is that if the patentee imposes such express the prohibition of reuse of the quad tube, can patentee prevent not only the direct purchaser, but also the defendant, the assignee of the product, from the refurbishment? In this regard, in order to impose such express prohibition against the third parties, such as assignees of the product, including the defendant, what kind of measures does the patentee have to make? For example, the putting express indication to the indication prohibiting reuse of the culture. So yeah, I'm sorry for a very long question, but yes, that is my question.
Thank you. It is not an easy question to answer in India because we do not have direct judgments on the point. However, if we notice the jurisprudence we've discussed just today and mentioned in Justice Verma's order also, there is one line of judgments, even in common law, which suggests that you can impose a condition and the purchaser and third parties are bound by the condition. On the other hand, you also have the US Supreme Court judgment that is ruling directly against the imposition of a condition, and that the condition will not remove exhaustion principle. So the views are inconsistent in that perspective. But from an Indian law perspective, ultimately, a court will decide it based on the statutory reference, whatever be the foreign position. And there is an argument to be made that because of the legislative change from the phrase authorized by the patentee to authorized by law, there's a strong argument to suggest that whatever be the restriction imposed by the patentee, that may not be entirely relevant consideration in determining exhaustion. But we will have to wait and see for an Indian judgment to actually expose this view.
Thank you. Okay, next, Han-san and Lee-san, could you please tell us your thoughts on differences from Korean attorneys' perspective?
Thank you. I will provide my comments. So regarding the patent exhaustion issue, so in the case of replacing the consumers, like the mock trial case, I think it is more appropriate to have a policy considerations than as when compared to the ordinary the patent cases, just simply copying the another's patents. So in our mock trial case, if the sale of the defendant's products is allowed, then consumers have more options for the packaging sheets with less expensive prices. So to my knowledge, common law countries put more policy considerations more than continental law countries or civil law countries like Japan and Korea. So I think this type of policy considerations works in favor of the defendants. So in my opinion, so under the common law systems, the defendant could have better chance of success. So perhaps, maybe this is my stretch opinion. So why the Indian team's decision is different from the decisions of the Korea and Japan. Thank you.
Thank you. Do you also have a particular question or comments to any of the attorneys from Japan or India?
Let me first as to Japan, so Shigetomi Sensei. So in my personal experience, so as a Korean practitioners for the topic of the international patent exhaustions, so we learned a lot about the BBS decision by the Japanese Supreme Court, because at that time we didn't have the Supreme Court decisions of the regarding the international patent exhaustions. Here's my question. So I wonder if the Japanese companies, it is a common practice for Japanese companies to put explicit disclaimers on their global sales to restrict the reimportation of their products into Japan. So in view of the PBS decisions.
Yes, thank you for your question. So as long as recognized, I am sorry to say that it is not common for Japanese companies to take measures such explicit disclaimers. There are not so many cases, and there is no the case law to specify each issue of BBS decision. But on the other hand, and as you know, as a practical matter, the patentee, if the patentee wishes or intends, the patentee should take measure to provide explicit disclaimers in order to secure its right to enforce based on the Japanese patent. And so I will give you some the practical tips. Okay, and so there are the unresolved issues, how to deal with the prevention of the international exhaustion under the BBS decision. And I will give you the 3 points. The first, it is very important that patentees should use the major languages, including such as English, for explicit disclaimer, so that the assignee of or users of a product can easily recognize such disclaimers. The second, and also the patentee should display such explicit disclaimers onto not only the products themselves, but also the sales or promotion materials of the product, so that the assignee can easily understand such a disclaimer. And the third, sometimes this indication or display can be deleted or destroyed by someone, so that it is very important for the patentee to take measure in a way that such explicit disclaimer cannot delete it or destroyed in the stream of commerce. That is my comment.
Thank you. How about a question for Indian attorney?
I'll make one quick question for the Indian team. Today I learned that the Indian court will review the foreign court decision in the context of exhaustion, like in the US or UK court case. This is my question. Please comment on whether or not the precedent case law of other countries, for example, Japan and Korea, would play any role regarding the patent exhaustions under the Indian legal system?
Yes, if I may answer your question. First of all, I think our courts, particularly in the field of intellectual property, have been extremely receptive to precedent from other jurisdictions. But just as Justice Verma pointed out, our first port of call will be the statute. And in the event that there is any ambiguity, we will look elsewhere. But at the same time, if foreign statute, for example, use the same expression or is in paramateria, as we say, then I think interpretations in Japan or Korea with respect to the same expressions would certainly be looked at by an Indian court.
Thank you.
Thank you. Okay, finally, Sai-san and Adachi-san, do you have any comment or question to any of the attorneys from Japan or Korea?
We have a question to the Japanese delegation. While deciding the case in the mock trial, it appears that the intended use of the patented article by the patentee, whether it was for a single use or multiple use, is a factor to be considered in exhaustion. However, if the law is silent on the intent of the patentee, would a Korean court nevertheless give weightage to such intent while applying the principle of exhaustion? This is the first question. And a follow-up, if possible, so that it's easier to finish it in one shot. If the intent is so relevant, does it have to be expressly stated somewhere, or could it be implied from the facts and circumstances of the case?
Thank you for your question. Actually, there's no express provision in the law. As the Judge Lee explained, we do have the case, the Fujifilm single-use case. Even though it's the trademark case, I think this is a very good reference for the patent exhaustion theory. So in that case, I think the article was for the single use originally. That also was the big factors for the Korean Supreme Court to decide. That means that the intent of the product can be one of the factors to be considered. And then I think the second question is very the good question and challenging question, whether or not the implied the use can be considered. Again, unfortunately, whether there's no case law on point, my understanding that I think the such intent can be implied, even though there is no express the indication of the use.
I have one question for you, for both Korea and Japan. If intent is so important, don't you think this detrimentally affects the second-hand market, especially with respect to refurbished products? Any comments on that?
Yeah, I think that's very, very important point, and that's the point why the Korea and Japan has the decision, and then India has a different decision, because the intent of use, in that sense, was designated by the patent holder, in that sense. So, but in the market has a different practice against the intent of the patent holder. So that I think how we can resolve this kind of situation. So in that sense, I think the intent of the patent holder should be considered. However, at the same time, this is my personal view, at the same time, the market situation, like what the user is doing, should be also considered.
Yes. So let me make some comments from the Japanese perspective. And as to the intent of patentee, as long as recognized, the Japanese courts can consider such the intent of patentee, but such factor is mere one of the various factors in deciding the issue. And also, there are some the possibility that the court tends to the intent of patentee in a way that if the patentee provides customers with repair services, such the patentee's act can infer the patentee's intent. And also, such product can be used more than one time by repair, and also the trade practice will be affirmed to justify the repair. So, and also as to I think that you mentioned as to the effect of second hand goods market, right? Yeah. So I think that your point is the very good point, and I think that your comment makes sense. And so that, as you know, this issue always includes the effect of the prohibition of the second-hand good market, which may lead the detrimental impact for the price and availability of the second-hand good market. So there will be always the very controversial issue how to prevent such the repair and the refurbish in this issue. So that is my comment.
Thank you. Did you already cover all the questions?
One more question to the Korean delegation. When doing the assessment, whether it is repair or production, when doing the assessment, whether it is repair or production, would the court also determine whether the replaced or repaired part is the inventive concept, or is that an irrelevant consideration?
Thank you for your good question. This is also a very, very important point. But under the Fujifilm case, again, the Korean Supreme Court did not consider the inventive nature of the repaired the places. Therefore, I think as of now, under the Korean law, the inventive aspect of the repaired portion is not required.
Thank you. Do you have any other comments or questions to any of the attorneys? We have actually plenty of time. No? Do you have? We all cover? Okay. Now we have lots of interesting comments in QA from attorneys of each jurisdiction. Thank you so much. And now we'd like to close this discussion between attorneys session, and back to you, Katsumoto.
Okay, thank you very much. It was very interesting discussion between attorneys. It's very suggestive for us too. And I'd like to express my sincere gratitude to all the speakers for the fruitful discussion. I believe that today's discussion will certainly contribute to our mutual understanding between three jurisdictions about IP and also the global harmonization. And personally, I'd like to take into account the way of thinking I have heard today into my study of IP. Thank you very much to all the speakers and also all the audience at venue and online. So the panel discussion is now closed. Thank you very much.
以上でパネルディスカッション、知的財産紛争解決の国際比較を終了いたします。ご登壇の皆様、ありがとうございました。